You bought land as is, but didn't know as is meant as in full of sewage. Can you flush the contract? This is the case that proves as is might mean as awful as it gets. Welcome to 99 Rights Online, and this is Lenawee County Bd of Health vs. Messerly, a 1982 Michigan Supreme Court case that asked, if you buy land and it turns out to be worthless, can you undo the deal? Meet Carl and Nancy Pickles. They just bought a charming little rental property from the Messerlys. Passive income, here we come. Except, surprise, the property came with a secret septic tank, illegally installed by a previous owner, and now, raw sewage violations. The county condemned it faster than you can say biohazard. The Pickles sued to rescind the contract. Their argument? Mutual mistake. They thought they were buying income-producing property. Turns out they bought a poop palace. But can a land contract be rescinded for mutual mistake when the buyers accepted the property as is? Well, rescission for mutual mistake is allowed only when the mistake. If the contract includes an as-is clause, the buyer assumes the risk of unknown defects. The Michigan Supreme Court found that, because the contract explicitly allocated risk to the buyers, rescission was not available, even though the mistake was genuine. The Michigan Supreme Court took a long sniff of this case and said, yep, it stinks, but legally, you're stuck with it. Mutual mistake? Yep. Everyone thought the property could be rented. Material mistake? Absolutely. The whole deal was based on that assumption. As-is clause, signed, sealed, and sewage delivered. Translation: the Pickles bought a poop palace, but they signed away their right to complain. The court basically said, you assumed the risk, now assume the consequences. The court reversed the lower rulings. The Pickles could not rescind the contract. The as-is clause meant they bore the risk of the sewage defect. For law students, this case is a cornerstone of mutual mistake, risk allocation, and contract avoidance. For buyers and sellers, it's a reminder. As is means you own the risk. If you want protection, negotiate it up front. Even though the mistake was real, rescission wasn't on the menu, because in contract law, as is means as in, legally doomed. Don't buy blind and end up with a legal lemon, or worse, a sewage-soaked money pit. Know your rights, read the fine print, and for the love of law, don't let an as-is clause become your villain origin story. Follow 99 Rights Online for breakdowns that keep your wallet safe, your contracts clean, and your dreams poop-free.